to our podcast. It comes to us courtesy of the Touro Law Review and the Touro College Jacob D. Fuchsberg Law Center. Our guest today is Professor Marianne Artuzio, and our topic is constitutional issues relating to vaccine mandates. Professor Artuzio, welcome.
Hello, it's good to be here.
Thank you. We have primarily a student audience, and they're always interested in people's careers, sort of the arc of their career, how they got to be where they are today. So before we start, if you wouldn't mind just telling us a little bit about your experiences as a lawyer and law professor.
Well, after graduating from Cornell Law School, I joined a legal services organization and did that work for about 15 years before I came to Touro. I did legal work on behalf of poor people, primarily in the area of health and welfare, social benefits issues. I came to Touro when I was asked to come to start a clinical program. At the time, Touro did not have any programs for clinics for experiential learning for students, and wanted to start a program where students could learn about law practice as part of their clinical education. So I began a program. We did at first Social Security disability, and eventually over the years expanded the clinical program to offer a greater variety of legal services to the community, as well as opportunities for students to learn. So we had, over the years, we had clinics in disaster relief and family law and civil rights litigation. Now we have immigration, family law, juvenile justice issues, veterans' rights. So I've been very privileged to be involved in expanding clinical programs, working with some wonderful members of the faculty and some fabulous students in doing legal work for clients and learning about law practice. So I was happy to do that. I loved it. In 2000, I think in 14, we started an institute in the area of elder law. It was called the Aging and Longevity Institute. I had been at the time operating an elder law clinic for approximately 15 years before that. And the Institute was an opportunity to pursue some advanced research and work in the area of aging law. So I did that for the last few years of my career, and then I retired from Touro about 3.5 years ago.
All right. Well, you certainly made a significant contribution to clinical education at Touro and far beyond. The last question I'll ask you in this regard, you're one of the professors who had a significant practice background before they moved into legal and clinical education. Mm-hmm. How did you get started as a practicing attorney? Was legal services your job right out of law school? Is that how that happened?
It was. It absolutely was. At the time I went into law school, legal services, when I graduated from law school, legal services had just begun. It was a very new organization established by President Johnson and the OEO. And so we were, it was a brand new world, really, of federal funding for legal services for poor people. And so at the time, I was absolutely delighted to be able to have that opportunity. I felt at the time that there were really innumerable legal needs and legal problems that had not been addressed for people of low income. And that was true. It was absolutely true. And so I practiced law in upstate New York for a while, and then in Westchester County with legal services organizations, doing a variety of work: civil rights work for landlord tenants, employment discrimination, pregnancy discrimination, until I was asked to come to Touro, which I'm so happy I did. It was really a wonderful career.
Good. Well, as a colleague of yours, I'm pleased to hear that. Let us now turn to our topic, which is constitutional issues as they relate to vaccine mandates. So, Professor Artuzio, if you would, start us off by giving us some background or history of mandates, and perhaps what some earlier Supreme Court cases have said relevant to these earlier vaccine issues.
Okay. Well, vaccination really in the Western world really started with Edward Jenner in about 1800, maybe 1799. He was the probably a figure that probably many of us studied in our world history classes, who developed a smallpox vaccine. And so in England, the vaccine was demonstrated to be effective, or at least believed to be effective in the around 1800. And 1808 was really the first time that there was any vaccine mandate in England. Wasn't a mandate for everyone by any means, but did require that guardians of the poor undertake a program of vaccination, and there was a requirement that anyone who brought a child to a guardian of the poor could ask that that child be vaccinated. Vaccination was considered at the time to be more urgent for lower classes, for poor people, because of the belief that it spread more quickly and more significantly in lower class populations. But eventually it was understood that vaccines were needed for the entire population. And so the first vaccine mandate really was in England in 1853, and in Europe even a bit earlier, in Germany and in Switzerland. Many of them had requirements for smallpox vaccination. At the time, that was the only vaccine that was available. Now, vaccines were not it wasn't a universal requirement for vaccination, but there were requirements that the public health officers, certainly in England, search for people for whom vaccination would be appropriate. So, and then in this country, in around 1900 or so, approximately, vaccines began to be mandated for smallpox in many cities in many areas of the country because of persistent outbreaks of smallpox. So those were really more general mandates. In fact, the leading Supreme Court case on the subject, Jackson against Massachusetts, came from the city of Cambridge, Massachusetts, which enacted a universal mandate that required all adults to get vaccinated for smallpox. There had been a significant outbreak, and this was the city's responsibility. The state had issued a law saying each city had permission to enact a mandate, and the city of Cambridge.
That's very interesting. I mean, that could almost be now. But
well, it could almost be now, but it's very different than the kind of vaccine mandates that we have now.
So let's so just to contrast, it almost sounds, or does sound, like the first broad scale mandate, and even if we speak on a relative basis, limited to a city, was actually in the US. I mean, the European mandates were not quite as broad. And if I understood you correctly, a state like Massachusetts that gave a city like Cambridge permission, the Cambridge mandate was for all citizens of that city?
That's right. All citizens who were adults, so the city could exempt children, right? So, and that's what the city did. Children were exempted under that rule.
I think I interrupted you as you were relating it to a Supreme Court case.
Well, right. So naturally, as you might expect, one Mr. Jacobson decided that his rights were being violated by. And this was in 1905. His rights were being violated by this rule, by the city ordinance, and brought a case that eventually wound its way up to the Supreme Court. Now, Mr. Jacobson didn't really articulate a particular constitutional argument other than to say he was entitled to his freedoms, that he was entitled to be free, that liberty allowed him to refuse to be vaccinated. This was also in 1905, before we had established what are now well understood as different levels of review, or different levels of scrutiny for constitutional arguments. as we're looking at constitutional arguments now today in the wake of the COVID vaccine virus, we also have to look back at the Jacobson case and try to understand what the Supreme Court meant and ruled at a time when the different tiers of review had not been established. But in any event, the Supreme Court in the Jacobson case said that as a matter of public health, that the state had the obligation as to secure public health, to secure the welfare, the well-being of the citizens of the state, and could delegate to each city the ability to make that determination regarding what was needed for the safety and protection of the people in the community. And so the Supreme Court essentially adopted what we recognize now as a rational basis test. Mr. Jacobson had argued that vaccination wasn't totally proven. There were still some people, some medical authorities at the time who claimed that vaccination was not firmly established. There were some dissenting opinions about vaccination, and therefore he should not be subjected to a medical procedure where there was significant medical disagreement. But the Supreme Court said the city is not obligated to, the city looked into the situation, conducted hearings, made findings, and decided that the great weight of the medical evidence was for the efficacy of vaccination. And therefore, the city was not obligated to accommodate Mr. Jacobson's desire not to be vaccinated because he felt that there was significant adverse or, contrary opinion. Mm-hmm. So the case really stands for the proposition, and has been cited again and again, that in the area of public health and public welfare, that the state has the authority to order vaccination. And the state's powers are wide-ranging and have to be suitable to the measure of danger or concern that the state is attempting to address. And it's interesting here that, as I said before, that this was a broad vaccination requirement. There were no exceptions. And it didn't apply to people based on their likelihood of getting smallpox, for example, right? It would apply to everyone in the city, which is not what most current vaccine mandates require.
Okay. Before we get to the current mandate, I find it interesting that you stated we didn't have tiers of review back then, but it seems to be interpreted as being a rational basis test. Then you said the case had been cited, I assume, in other public health cases and perhaps even other vaccine cases moving forward from 1905, for maybe the rest of the 20th century. Were these public health and or other vaccine cases, has it been sort of settled that they're using a rational basis test, or is that not currently agreed upon?
Well, I think that currently courts have said, well, it looks like they used a rational basis test. That's what it seems that they're talking about, because they talked about, because the court examined the ability of a governmental agency to enact protective legislation for public health and welfare. But
if I may, how about cases going forward? Like now that we have 3 tiers of review, have the more modern public health cases or the post-tier review established public health cases, are they using a rational basis test, or are they using more elevated scrutiny?
Well, we don't have many cases here that have really come to any decision. We've got a lot of cases with preliminary injunctions, but certainly the Supreme Court has not decided a vaccine case. The most recent cases have been ones based on a preliminary injunction. And a lot of the cases where there might have been an opportunity to to make a ruling have become moot because, as you know, as we all know from the news, that vaccine mandates change. That vaccine mandates change. That rule, the science changed, the current condition of the pandemic has changed, and therefore, some cases where this might have been explored have been mooted out just because of changes in the rules. But we've seen, for example, the rational basis type standard adopted in some of the cases from the 40s, the 30s and 40s that challenged vaccine mandates for public school entry, for students to enter public schools. It's been well established. I think there are all states. I believe all states have vaccine mandates for public schools, for public education. I think only 6 of them have like a religious exemption. Almost all have a medical exemption. If there's a medical reason why a child shouldn't get a particular vaccine. I think only 6 have a religious exemption. New York used to for public school education. New York used to until 2019, and the religious exemption for schools was eliminated. But in recent litigation, many of the plaintiffs have claimed religious exemption and claimed that they should be entitled to a religious exemption from being compelled to take the vaccine. Right.
So we now, I think, have two follow-up questions here. The second one will be, let's talk about the nature of the constitutional challenges. But before we get to that, and you've alluded to this several times, that there have been historically and currently different kinds of vaccine mandates.
Right.
On different scopes. So which ones do you think are most relevant or most typical with respect to COVID-19? What are the dynamics of those mandates?
Well, I guess I think I've been primarily talking about the different kind of mandates that have occurred in relation to COVID-19. Just as an example, there are some states have mandates that require all healthcare workers, for example, who have certain kinds of patient-facing responsibilities. Others require people in all healthcare units to have, in all healthcare settings to have a vaccine. We know that the federal government is now requiring vaccines for all federal employees. Currently, I think starting in January, the federal government is going to require vaccines for all federal contractors, employees of all federal contractors, as well as employers of I believe it's 100 employees or more, right? Under I guess a Commerce Clause theory. So different groups of people can be subject to mandates, and also there's a great variety in the kind of exceptions or exclusions from the mandates. So many vaccine mandates, for example, that have been enacted in a number of states, allow an individual to be able basically to test out of the vaccine. In other words, to be able to, they have to take a vaccine, COVID test within a certain frequency. They may be required to wear masks and take a test. But so many of these cases where we talk about vaccine mandates are not really a mandate. It's just it's a requirement with essentially escape clause if you if you follow other obligations or other tasks. So there are very few actually situations where there's an absolute mandate that a person has to be vaccinated or else there's no other consequence.
Okay, so we haven't gone back to Cambridge at the beginning of You
We
say?
have not at all, right? And I think, in fact, of course, that the Jacobson case might be looked at quite differently today, right? We have a different understanding, I think, now about rights of liberty and bodily integrity. You know, if we look at, for example, the Cruzon case or Washington against Glucksberg, and these are cases that involved unwanted medical, well, Cruzon involved a desire to avoid unwanted medical treatment. Washington against Glucksberg really had, the Supreme Court decided that there was really no constitutional right for someone to have physician-assisted dying. But both of those cases involved, required the courts to look at constitutional and common law bases for a right of bodily integrity, a right to be free from intrusion on your physical self, to be free of unwanted medical treatment. And in some of these cases, people are arguing that they have that right to be free of unwanted medical treatment, and make the argument that the vaccine is unwanted medical treatment. And I think that argument certainly has some purchase today, certainly more than it did in the Jacobson case, even in the light of the significant urgency of stopping the spread of this disease.
Mhm. Well, then let's turn to that. I mean, certainly that background you've just given us, as well as your observation that the vaccines cover all sorts of groups and have a variety of exceptions. And so it can bring us to really the heart of it, which is the constitutional challenges to the vaccine mandates, whether they be First Amendment or Title VII, or deprivation of liberty, medical privacy. I mean, these are all your, Professor Artuzio, these are all, that's sort of your summary of some of the constitutional arguments that have been made. So would you please then speak to some of these arguments based on these constitutional doctrines and clauses?
Well, probably, actually, I would like to say one thing first, and that is that religious exemptions to vaccine requirements have been, pretty standard, have been around for a very, very long time. On the other hand, the desire to claim a religious exemption has become has increased significantly since the rise of the anti-vax movement. There are very few religions, recognized, known religions, where there is a religious injunction against vaccination. Very, very few. I'm not an expert on every possible religion, but Christian Science is one that's well known, and there may be a few others, but it is not the doctrine of most religions in this country to refuse a vaccination. And yet, many people are claiming religious exemption for the vaccination. In fact, I just read something recently that the city of New York is requiring vaccines for police and fire, but they have given a religious exemption. And I've read that the police and I believe the police department is thousands of applications behind in adjudicating claims for religious exemption for members of the New York City police force. So it's become a very common, I wouldn't say a very frequent objection to vaccines. One which then requires, the public officials to try to ascertain the sincerity and the genuineness of someone's claim of an exemption based on religious belief. But that aside, the claim for religious exemption that's been made is that if an individual has a sincere religious objection, they cannot be compelled to forego a government benefit at the cost of sacrificing, their religious practice or their religious belief. And most of these come up in the context of employment mandates, right? And college mandates and school mandates. So the cases that have generated the most litigation are obviously requirements for vaccines in order to retain employment, or vaccines in order to attend schools, colleges. There hasn't been much very much in primary school, because primarily there are, it's been such a long established tradition for vaccines requirements for children in elementary school. But many states have had vaccine requirements for colleges and universities as well. But in any event, so the arguments here are that the state vaccine mandates, and let's take a look at the Arizona case. And the district court in Arizona was one of the few cases that recently has upheld a vaccine mandate or a school rule about a vaccine based on religious principles. Now, in this case, it was very difficult to ascertain what the individual's religious belief was, but the court accepted that this was a sincere religious belief. The case came to us in the district court in Arizona because nursing students were challenging a vaccine requirement or the school policy that required them to follow the vaccine requirements of their clinical placements. These were nursing students, and part of their education was a requirement that they go on a clinical rotation. And so the college's rule was that when you were on the clinical rotation, you had to follow the vaccine mandate of that facility. So students were placed in nursing homes and hospitals and other medical facilities, and students were required. The Arizona District Court said that the policy, because it impinged on their religious freedom, their religious belief, right? It had to be narrowly tailored, and it had to, the policy had to be narrowly tailored to fit the had to be narrowly tailored to not entrench on the students' individual religious beliefs unnecessarily, and so because the religion is a fundamental right, that strict scrutiny really had to apply. And so what the court looked at was the possibility that there could be other ways to allow these students to get their clinical requirements without having to forego graduation. Now, it was interesting what the court said was that the school had offered a number of alternatives here. And the school said, well, you may offer these alternatives, but the students are entitled as part of their educational program to graduate, and putting off graduation to allow the pandemic to pass, or putting off their graduation to be able to do their clinical their clinical rotation in some other way was not sufficient protection for their religious beliefs, that they were entitled. They couldn't forego their education or be forced to forego their education at the cost of violating their religious principles. Now, I find it interesting here that we really don't know what these religious principles were from this case. I suppose that, the court accepted that these were genuine religious beliefs. Now, in a more recent case that was decided just earlier this month, We the Patriots against Hochul from New York, was a case in which the healthcare workers challenged New York State's mandate for vaccination for healthcare workers without any requirement for a religious exemption. In other words, in New York, healthcare workers are required, healthcare workers, and virtually all of them, are required to be vaccinated. There's no religious exemption. So the argument was the same, that this was an unconstitutional infringement upon their right. And one of the things that is so interesting here that they cited as a reason for claiming that this rule targeted religion was because there was an interim rule in effect before the permanent rule went into effect. There'd been an interim rule, I think in I think the beginning of August or so, that did have a religious exemption. And then when the permanent rule went into effect after study by the State Healthcare Policy Council, the permanent rule did not allow a religious exemption, and therefore the parties claimed this was a policy that specifically had targeted religion, and that the Supreme Court's decision in I think it was Lumuki, that even a rule of general applicability, even a rule that was generally applicable and seemed neutral on its face, could violate First Amendment rights if it was intended or targeted for against a particular religion or against a particular religious practice. But here, so the parties in the New York case said, well, we used to have a religious exemption and now you removed it, so you're particularly targeting religion. Court didn't really accept that argument. But the parties also argued that Title VII of the Civil Rights Act required the employer to make an accommodation for religious practice or religious beliefs. Title VII.
Let's certainly talk about the Title VII issue, but just as a transition question, did the court that decided the New York case, did you get the impression that they were doing a strict scrutiny analysis? Because it's so hard to sustain anything if it's subject to strict scrutiny.
No, they did not.
They did not. Okay.
They did not. They absolutely did not. They
All right.
cited Jacobson and a rational basis standard. So at the moment we're in a rational basis standard world, but I do have to say that religious concerns are becoming, I would say, more prominent with the Supreme Court in recent days, and so I think there is some cause for I guess speculation as to whether or not the Supreme Court will uphold a Jacobson type case, or at least a vaccine mandate case against a religious subjection, religious freedom objection. I mean, the Supreme Court has not really had a vaccine case, except that recently they upheld the denial of injunction in a case brought by students from the University of Indiana who sought an injunction against the university's policies for vaccines. So the Supreme Court upheld the denial of an injunction in that case. But if we look at what the Supreme Court has done in religious gatherings cases, we see that there really has been a shift to accommodate, to afford a greater respect for religious concerns. In the beginning of the pandemic, as we all remember, there were many city ordinances that banned gatherings of 100 or more, 25 or more, whatever it was in a particular city, and those rules were pretty much upheld, even in cases where the challenges were brought by religious organizations, which said that we have a religious right to gather to worship, and a rule that limits the number of people who can worship in our churches impinges on our religious freedom. So last year in 2020, and even up to, the beginning of this year, well, no, up to 2020, those cases, even ones involving church attendance, the Supreme Court had turned away challenges to those, and the request for a preliminary injunction in those cases until November of last year. And what happened in November of last year was, after the death of Ruth Bader Ginsburg, Amy Coney Barrett joined the court. And after that, and when she was on the court, the court's position switched. And I think it was a case from California, the Supreme Court did grant a preliminary injunction against a rule in California that I believe limited, I think it was, the case was Tolson against Newsom, but limited the California rule, I believe, limited religious observances to 10 or more people. So Supreme Court, granted the preliminary injunction. So we see a shift in that realm. I don't know if that's going to happen in vaccine mandate cases. We don't know. It's a bit of a different concern, but they both relate to public health measures that are designed to stop the spread of the pandemic.
All right.
Both of them.
So, I mean, to try to maybe sum this up with respect to religion, we do not have any Supreme Court COVID-19 religion cases. Rather, what we have is religious challenges. One case where the court basically didn't get involved, allow an injunction to, or allow the denial of an injunction to stand, but an overall, perhaps, well, more than perhaps, shift in the role that religion will play in terms of challenging regulations and maybe even being more successful in these challenges. So that's one interesting thing. In the time we have left, would you like to talk about a challenge based on, I mean, it could be Title VII, which I guess is also a religious challenge, or any of the deprivation of liberty or privacy challenges? Could you maybe talk about one other type of challenge?
Well, Title VII, of course, prohibits discrimination based on religion and requires Title VII, the Federal Civil Rights Act, and requires an employer to make a reasonable accommodation to an employee's religious beliefs. And so some cases have argued that excuse me, the failure to provide a religious exemption here to a vaccine mandate is a violation of not only the Federal Civil Rights Act, but also the Religious Freedom Restoration Act, right? Because the employers are not giving a reasonable accommodation to religious practice. Those arguments have so far not been winning arguments, although I guess it depends upon what kind of accommodations are being offered or suggested by the parties. The courts have so far have said that the employer has an obligation to make an accommodation, but that accommodation does not mean allowing the individual to spread the disease, deadly disease. So employers are obligated to offer an accommodation. That accommodation might be a different assignment, for example, if that assignment is one that's consistent with the ability or that the individual would not be spreading the disease. For example, in some of the education cases, courts have said, well, a person could, perhaps take courses online, for example, rather than that's an accommodation that the person should be able to have or take courses at another institution and get that credit transferred, for example. But the accommodation, the issues where it's particularly difficult is in the healthcare area, which is where so many of the mandates have occurred. Because if you're in a medical setting, there are very few things that you can do that will not enable, have you be able to expose someone to a disease. Just walking to your place of business, for example, to your place of work, may offer an opportunity for disease to be spread. But the employer is required under those laws to offer an accommodation if it's a reasonable accommodation and one that does not create undue hardship for the employer. And certainly in the context of other kinds of employment, when we get to situations where where government contractors, which may have nothing to do with health settings, or President Biden's requirement that employers over 100 employees will have to have mandates or mask requirements or such. Those may have nothing to do with health. Most of them will have nothing to do with health situations or health settings, and consequently the ability to spread the disease to more vulnerable people in health settings may be viewed quite differently. So I'm not sure, we're seeing an evolving landscape. We're seeing an evolving disease, which requires different kinds of protective measures. And so we'll just have to see what the court does. But so far, we don't have any clear indication of where the Supreme Court is going to go on this, just hints here and there.
Okay. And then I guess maybe our last question, again, staying focused on these very interesting constitutional challenges, any that simply do not speak to religion at all, but instead some kind of privacy invasion or deprivation of liberty / bodily integrity? Have there been any of those argued before any courts?
Well, yes, there have been. The case in, let's see, in Indiana, the Indiana University case, the case in which the Supreme Court just recently denied the preliminary injunction. The students did allege invasion of bodily integrity, the requirement that they be vaccinated. But the court there said, this is not a requirement to be vaccinated. If you're not, you have to be vaccinated. And if you're not, you have to be tested. They were alternatives. There were a testing regime. The students had to wear masks if they weren't vaccinated. They had to, I believe, maintain certain social distance requirements in certain settings. So the court said, this isn't Jacobson. It's not a rule that you have to be vaccinated. It's the vaccination or undertake other measures. So the court said there's no violation of bodily integrity when you have a choice here. Right? The alternatives are there. So that's how the courts have looked at a lot of these requirements. As long as there's an alternative, it's not an invasion of bodily integrity or a violation of your medical privacy.
Okay. If I could sort of pull one sentence from your presentation, sort of by way of almost as summing up, it's that we don't know what the Supreme Court of the United States will do. We only have some hints.
Exactly.
But I don't want to be the one summing up. Or I don't mind it, but I would also want to give you an opportunity to leave us with any closing thoughts or insights that you may have.
Well,
I
think we have to recognize that in the in the era of a public emergency, there will be many different kinds of responses. There's a certain hysteria over vaccine mandates, I think. in Ohio, in fact, I think Ohio even passed a state law that prohibited having vaccine mandates by employers or something. There's a certain hysteria about it, but we have a long history of requiring vaccines as a public health measure. And I think that the laws of protecting public health are now coming up against a renewed sense of religious liberty and the significance of protecting religious beliefs. So while as you said, or I said, that we don't know what the Supreme Court will do, but I think the arguments of religious liberty, to the extent that it's based on a true religious or moral belief, and I think those arguments are going to have be given more weight. But I think we have to recognize that deciding what's a sincerely held religious belief is itself a fraught problem, is itself a fraught question. You don't have to be a member of a recognized religion. It's easier if you are, but you don't have to be a member of a recognized religion. And our institutions, our government agencies are not particularly well equipped to inquire into someone's, in a detailed way, to inquire into someone's sincere religious belief about something as unreligious in a way as a vaccine. And I don't mean to be flip about it, but vaccines in medical care are generally not the primary focus of most religious belief, I guess, right? So what do we have to do? If we allow some kind of exemption based on religious beliefs, does that mean that the Commissioner of New York's police in New York City is going to have to undertake some kind of adjudication process to determine the sincerity of an individual's religious belief and to examine into their history and their personal activity over their lifetime as to whether or not they have followed this, particular belief? So it's very problematic, I think, just as a practical matter, aside from the constitutional and the legal arguments. As a practical matter, it's extremely problematic to do this.
I think it's been problematic in every context. Anytime you need to examine sincerity or even what is a religion, I mean, those are some of the biggest
absolutely
proclamations we have.
Right.
Professor Artuzio, thank you very much. Professor
I was
Marianne,
glad to be here.
Our pleasure. Professor Marianne Artuzio has been speaking with us about constitutional issues as it relates to vaccine mandates. I've been your moderator, Professor Peter Zablotsky of Touro Law Center. Professor Artuzio, thank you. Be well, and it's been a pleasure listening to you.
Thank you. It's good to see you again, Peter. Bye.